Hello and good evening. I was talking earlier about the legal documents and how to translate them, about legal translation and how to deal with some texts, whether they are English and Arabic. And as I said before, that you need to be a little bit more conversant, if you like. You need to know the language of both legal languages of both systems. You need to understand the English document and the English system as well with it, that comes with some Latin words, Latin expressions even. Ab initio, for example, they will use some terms that are already in Latin, already built into the legal language in English, which you need to know that you have to use them and in English. Then when it comes to Arabic, also there are some words there that are used that are in the legal system. Some of them are built in some, depending on if it is Islamic law or whatever law that you are actually dealing with in the Arab world that you are applying. So that is civil law. You need to know that language. You need to understand it. You need to ask lawyers both in English and in Arabic. You need to read about how texts in English, legal texts are in English, and how legal texts are in Arabic. Maybe do parallel text analysis. Look at the two texts of two documents, two contracts, for example, and see how they look like. Also, for example, if we were talking about marriage certificates or marriage contracts, you need to see how it is done in English and how it's done in Arabic, because sometimes in Arabic, sometimes in English, for example, for better or worse, في السراء والضراء, for example, but we don't use that in Arabic, that you have to stay with your husband, or the husband needs to stay with his wife in sickness and in health. So it's not actually, even this formula is not in the Arabic contract. Therefore, it's not really, it has got a certain way of saying it, and then you have to move it to English. Here, in a way, we are talking about relevance theory in a way, where you are, there are things like inshallah, alhamdulillah, in the spoken Arabic and relating to perhaps some legal context or environment, which may actually be not needed for translation in the other language. For example, you can say hope so, I hope so, or hopefully, for inshallah. And so that is really something relating to the environment in which that legal document is. Now, as I said earlier about emotive diction, lack of emotive diction in legal language in English as a text type, instructional, that is, that language is not evaluative. There's no evaluative element in it. It's not like the expository text types where there's a little bit of evaluation or evaluativeness there in there, as opposed to also the other type, the third type, which is not the propositional, not the the instructional. So the instructional is the one that is to be instructing through law, to instruct through law. That is what the legal language is, to give instructions to both parties, and both parties means al-atraf wa al-tarafain, to both parties. And that's أو إلى الجانبين. لكن تستخدم الطرفين أكثر in Arabic for the word two parties. And there are definitions as well at the beginning of the contract, like premises. Premises means al-aqar. Sometimes it's called you can say the building, which is the premises, meaning the whole building, the house. So this is with regards to house buying and land buying, landlords, and landlady, which is صاحبة العقار, and landlord, صاحب العقار, not necessarily the al-ard, because you are owning a property. Property means here, it means al-aqar, and does not mean al-mulkiyya. Even though sometimes you can use it as mulkiyya, but possession is mulkiyya. And then can be intellectual property. It can be mulkiyya fikriya, yes, but usually property, it means العقار نفسه, if you are using it. And sometimes you use it in capital letter. For example, you say company and client in C capital. That's because it's two parties. So you know that these are the two parties. They write them company C capital and client C capital, or customer C capital. So that is really to show that these are the two parties. And there is no there are no pronouns, lots of pronouns, like for example he or she. They don't use that. Why? This is a question. It's actually because they want to make sure that they are referring to the same person, which is the landlord, for example. Because the landlord might be, as a definition, might say the landlord can be either him in person, Mr. whoever, or any of his relatives who can be female. So it's a problem when you come to write down in the middle of the or the body of the text, and you write the landlord. If you say he, and then his daughter comes in and collects the rent, the tenant might say, look, in the contract it doesn't say that your daughter comes in and collects rent, because you said he. So you avoid he and she and they in this, and you just always say the two parties. If you are going to refer to both of them, say both parties. You don't say they at all. You use it sometimes, but not a lot. So you minimize the amount of pronouns you use in legal language because of the fact that you want to eliminate ambiguity. And that is the whole thing about contracts, because it's the way you interpret the contract afterwards. And sometimes, some companies tend to say, look, we have to consider which one is the original text to go to court with, because if there are two copies of the same text, which one is to put forward to the court. Sometimes they might actually to specify and say in the contract that only the English copy is the one that to be accepted in courts and not the Arabic one, or only the Arabic one is to be accepted and not the English one, because the Arabic one is the original. This is how specific contracts are, and how specific the law language in both sides, the legal language in both sides, the English and the Arabic. So therefore it is very, very mandatory. Yani ilzaman, mandatory is a very legal word as well, obligatory as well, but mandatory is more used. Both parties have the right to do whatever is needed. يحق لكلا الطرفين في هذا. And that's why there's no confusion as to which party. That's why they do the repetition of the same party that they are talking about. If they're talking about tenant, they will just always, tenant does this, landlord does that. Landlord does this, tenant does that. If we go to countries or court and let's say the client or the accused, and then they also do the same thing. So they always have to refer to them as, for example, owner and tenant. They can. So you say if owner does this, tenant does that. Owner does this, tenant does that. Okay. Petitioner does this, respondent does that. يعني مقدم الدعوة petitioner and respondent الذي يرد على الدعوة. Okay. So they say petitioner, respondent, petitioner, respondent. They don't say Mr. whoever and Mrs. whoever. They don't say that in the contract or in the communication between lawyers. They say my client. My client means موكلي. يعني مش زبوني, because the word customer is زبوني when you are talking about, let's say, a company which sells some products, some goods. But here you say client. Client means موكلي. And of course the lawyers will talk to each other, the respondent lawyer, the petitioner lawyer. Okay? In defense they say this and whatever. So you see, this is how legal language is used, so that they don't confuse matters by using he and she and by using these pronouns of they, and then it's a problem to mean what do you mean by they? It can be the damages, they. No, they don't say that. Say you pay for damages, because and then they repeat the word damages everywhere, and they might say property, and they then define what property means. It means all the house without the garden, or with the garden, or all the house without the top floor, or whatever. And they carry on with a capital P throughout the contract, property, 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 with a P capital all the way. They don't even use the property. So even the word the is dropped when it comes to the parties, the two parties. You say, first party, second party, first party, second party. First party does this, second party does that. Okay? Shall do that. You usually use shall, and then يعمل, يدفع. So it's in present all the time in Arabic. يدفع الطرف الأول يقدم الطرف الثاني. الأول الثاني الطرف الأول الطرف الثاني, all the way through. So you don't say سوف يدفع, because they might say, oh, you said سوف and you didn't say when to pay. Okay, so there's a kind of like terminology, which is, we need to learn that terminology in the legal systems of both languages, the English language and the Arabic language, and that is really one of the most difficult challenges that are facing the translator and the interpreter too, in order to understand what these words mean and not confuse them when you are actually in a discussion in an interpreting booth or in the court, and you are interpreting for two clients, for the client, for the accused, if you like, if he's a criminal. So you always have to be very clear in legal language in both systems, and that is why this legal system is like that. It's actually put in such a way that you cannot confuse or have any ambiguity whatsoever in the text. And even that, I mean, this is what you follow. You follow the letter of the law, or the spirit of the law, as they say. For example, sometimes things that are written in the law which can be interpreted differently, because they're looking at the spirit of the law to implement something. For example, in contracts, you would say impediment. You'd say AIAC شرعي, legal impediment. عائق شرعي, and then the word شرعي, for example, شرع الشريعة, sharia, which means the legal Islamic law, which is sharia. But then, of course, in English, it's a legislative body, هيئة تشريعية, which is a different thing, which has got things to do with the structure of the country, because there are three powers. One of the judicial is a third power, which is supposed to be separate. Judicial means السلطة القضائية, the authority, and what is their jurisdiction, what is their يعني صلاحيتهم, سلطتهم أين تقع. And this kind of judiciary system is by the judiciary authority, who will decide on certain legal matters. Of course, there's the legislative system, which has nothing to do with the judiciary system. Judiciary system القضائي, legislative means التشريعي, which means it comes from the parliament here. The parliament puts a law which has which puts forward some sort of a suggestion for to get a decree مرسوم, and this decree will be decided by the head of the state, and that is it becomes a decree by the president, for example, مرسوم, and مرسوم is part of the law as well. And it becomes, they pass also these laws to be approved by the parliament, البرلمان, which is the legislative body in the country. Yani you have to understand this as well. If you are talking about international law, you need to understand also how the structure of the country is. What's the difference between government, for example, and state? The state of the country. State, يعني الدولة. الدولة, which means it's the only represented by the head of state and the foreign minister or foreign ministry, يعني وزارة الخارجية ورئيس الدولة. These are الدولة, which has its own organizations, and that. There's الحكومة, which is a different kind of system, which is the executive system, يعني السلطة التنفيذية, which actually carries out what's the law, enforces the law. يعني مثلا الهوم اوفيس اللي هو وزارة الداخلية في بريطانيا, you have to know that home office means وزارة الداخلية, for example. Whereas in America is you don't say وزارة you say Interior Ministry of Interior, and Secretary of State وزير الخارجية, for example, whereas is foreign minister in Britain is وزير الخارجية. So you need to understand also the titles of each country is different when you talk about international law and international countries who are dealing with it, and who is the one who is actually executive. The executive authority is in the ministers area, where they enforce the actual law through their own ministries. For example, if the Ministry of Health imposes laws relating to health, and Ministry of Foreign Home Ministry will be Home Office will be imposing things relating to shurta of the police and all the security and so on. So you need to know, to understand these systems here. Also on the international level, you need to understand, for example, the UN. The UN is political, what entity, you need to know how many members, for example, and how many organizations, big organizations in the UN. Security Council, which consists of 15 members, 5 of them permanent members, أعضاء دائمين في مجلس الأمن. You need to know that. These are decision makers who are veto. They use the veto to actually reject any decision that's going to be taken. Of course, it's not called decision in the UN, it's called resolution. So a resolution is qarar, for example, and not decision. Decision comes under company. Company will take qarar. You can't say resolution for a company. This company is taking a resolution. You say that for a bigger organization like the UN, a big international organization. The word international itself, is it dually or alami? If we talk about the countries themselves, if you got an international conference and there are countries participating, countries يعني states, دول يعني رئيس الدولة, whether he is a prime minister or she is a prime minister or the president or the king, these are the ones that are participating in an international conference. Like the G20, for example. It's all international entities, and they are all heads of states, رؤساء دول. These are زعماء دول. But these are actually this is an international conference, يعني مؤتمر دولي. And then you have another international conference which is عالمي, not دولي. How? Because the members who are attending are from different countries. Like, for example, academics are meeting about, let's say, a health issue. Academics. And they are not representing their countries, they are actually just going in because they are academics from different countries, coming in from Italy, from Germany, from Egypt, from whatever, from Saudi Arabia and all others. So this is what's happening here. So you can't say, you say there is an international symposium, for example, symposium. يعني منتدى عالمي. عالمي because the people or the delegates, يعني الوفود, the delegates, the people who are participating, the participants in the conference are not representing their own country. They are only representing themselves. They're coming from a certain country, but they represent themselves, and they are not representing the whole country, and they are not speaking on behalf of the whole country. And that is the issue here. So that's why it becomes very legal when there is a legal dispute going on. So you need to understand that when you go to the international or tribunal, يعني محكمة الصلح الدولية, to settle disputes as well, which is the International Court of Justice, for example. So this is really an issue of that. On the other hand, also, I mean, going back to the legal language, there is hereinafter, for example, hereinafter, the word hereinafter. It means in the contract, it means فيما بعد في هذا العقد. يعني you have to say في هذا العقد فيما بعد. If it's called عقد. إذا كان معاهدة فيما بعد في هذه المعاهدة. Treaty. or convention, and so on. So you are actually looking at some adverbs coming with each other with prepositions, here and after, hereby, hereby الموقع أدنى, hereby, بموجب هذا العقد, and so on. So these are really specific terms which once you learn them, you're there. Okay? And therein, for example, they say therein, therein and herein. Herein means في هذا العقد. Herein في هذا العقد. Therein في تلك الوثيقة اللي هي خارج العقد. ممكن تكون يعني ملحق, appendices to the contract or something. So you say therein, يعني في تلك الوثيقة التي هي ملحقة بالعقد, which is appended to the appendix or annexed. Sometimes they use as annexes. They don't say appendices in the contracts. They say annexes. Annexes means ملحقات to the contract. So herein, therein, في هذا العقد, في ذلك العقد, في ذلك الوثيقة, herein after, and therein after as well. So all of these are terms that you need to remember how to use them, and how thereof, hereof. Hereof means يعني جزء من هذا العقد, because of this contract. That's what hereof means. And thereof means جزء من ذلك الوثيقة الملحقة بالعقد أيضا. I hope that I've actually given you some of these tips about legal translation, which I hope that you'll understand why these challenges are so great for legal translators. And of course there's a sworn in, they say sworn in translators. Sworn in, what does it mean really? It means that you have to actually take this document and swear that you are actually being as honest as you, objective as you are, and transferring it from one language to another. That's all. That's a sworn in translator. And in actual fact, you don't need to be sworn in translator. You need, as a translator, you have a duty on you. It's like, you know, the Hippocratic oath for doctors. They have to swear that they will treat anybody regardless of their race, origin, and so on and so forth. The same applies to you. And you don't need to be sworn in, really, as a translator. You have to be trusted that you are actually conveying everything in this text, which is a document. Whether it's a passport or an ID, you don't change the number of the ID and so on, or the date and so on, because it's written in Indian letters, which are at the moment used in Syria, Lebanon, and so on. Or the Arabic numerals, which are used in Morocco and the North Africa. They still keep the Arabic numerals, which are written as in number 1, which some Arabs think that they are actually English numbers. They are not, because the English or the European numbers, Europeans used to use Roman numbers, and then they moved on and used the Arabic numbers, numerals. And the Arabs have used the Indian because of trade and so on. I wish that you have learned something from this. I would like to thank you very much for listening, and goodbye.